there's no garnishment. In today's video, I'll go over the basics of garnishment in Texas. Welcome to another edition of Coffee with Law. My name is Benjamin Sanchez, and I represent consumers, tenants, and homeowners during life setbacks to help them move forward. Let's talk about garnishment in Texas. Everyone believes that there is no garnishment in Texas, but that's not really the case. What Texas doesn't allow is for a creditor, except for two specific exceptions, to garnish your wages from your employer. The IRS and child support are the exceptions in which people can garnish your wages directly from your employer before that paycheck gets to you. Now, there's only a certain limit that they can garnish, but those are the two exceptions. However, there is also garnishment of bank accounts, which is totally separate from the garnishment of paychecks. A creditor can garnish your bank account if they have a judgment and they apply with the court, they file an application for writ of garnishment. If the court grants that application, then usually what happens is that the creditor will notify the bank, and then the bank will withhold that money. Now, it doesn't mean that that money is automatically given to the creditor. What happens is that the bank has to answer. Basically, it's a new lawsuit, but basically the bank has to answer the application for writ of garnishment. In addition, the bank will notify you as the customer that, hey, we're withholding the money based upon this application and writ of garnishment we received from the court. You have so many days to respond if you want to respond. While it is not necessary for you as the consumer or the debtor to respond to the application, of course, I always encourage that you do. I think a running theme that I've been trying to convince you of is to never ignore a legal proceeding. If you simply do something with a legal proceeding, you will be better off than 99% of the people out there. So, when a bank does the application, gets a writ, sends it over to when the creditor does an application, gets a writ, and sends it over to the bank will withhold the money. The bank will answer the application, which is basically a lawsuit. You have the ability to answer that as well and figure out whether or not that debt is a true debt or whether that judgment really should exist against you. Now, remember, the garnishment from a bank account by a creditor can only come after a judgment. In other words, if Best Buy says that you owe money, they can't go to the court and ask for writ of garnishment. They have to reduce that debt to a judgment. So they have to file a debt collection lawsuit, which you will answer as well. Supposing there is a judgment, then that's when the writ of garnishment comes into play. Now, what I have done for many of my clients is this: depending upon the age of the debt, and sometimes not, we will file what's called a bill of review. A bill of review is a new lawsuit that complains about the judgment and says that the court should not have issued the judgment because it was improper somehow. Most of the time, that's due to the consumer never being notified about the lawsuit, and therefore the creditor getting a default judgment against the consumer. What happens? The creditor then lies for a few years, lies in wait or lays in wait for a few years, and then all of a sudden pounces on the writ of garnishment. And then you're stuck with that money coming out of your account, not having realized that there was even a judgment. Now, there are some other things that have to take place for that to happen, but that's generally the scenario. An attorney can help file a bill of review if you were never served with a lawsuit and ask the judge to not issue the writ of garnishment, to deny the writ of garnishment, or to at least stay the writ of garnishment while the bill of review is pending. And that is what garnishment is like in Texas. So remember, a creditor cannot garnish your bank account except with the IRS and child support. However, a creditor cannot garnish your wages. Apologize. A creditor cannot garnish your wages except with the IRS and child support. But a creditor can garnish your bank account, but only after they get a judgment and only after they filed an application for writ of garnishment with the court. I hope this has been helpful. I hope you've had a good week and you've learned some things about debt collection. And I wish you a very, very good day. Thank you. Bye-bye.